Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Today my group and I will discuss about one study case in our textbook, which is Cenco's Incorporated with Seidman Seidman 1982, liability to clients. For the introduction, this case is an important case about auditor responsibility in finding client fraud. From 1970 to 1975, Cenco's management inflated inventory values to get cheaper loans and bigger insurance payouts. An employee uncovered the fraud and reported it to the SEC, leading to a lawsuit by stockholders against Cenco's, its management, and the audit firm Seidman Seidman. The auditors settled this lawsuit for $3.5 million. Later, Cenco's new management sued the auditors for not catching the fraud, claiming breach of contract, negligence, and fraud. This case highlights the significant legal and professional pressure on auditors to detect fraud.
So, for the fact of the case, in the early 1970s, Cenco management engaged in massive fraud to inflate inventory values, regarding favorable loans and insurance settlements. After discovery, stockholder filed a class action suit settled by Cenco auditors for $3.5 million. New management then sued the auditor for breach of contract, negligence, and fraud. The 7th Circuit of Court of Appeals ruled that the auditor were not responsible, as the extensive fraud by Cenco management hindered their detection efforts, thus negating the charges against the auditors.
There are two liability in case of management fraud, which the first one is the defensive claim of management wrongdoing. The court in the case recognized that when management itself is involved in fraud, it can significantly distract the auditor ability to detect such fraud. The auditor defense was that they made diligent attempt to follow out fraud indicator, but the constant effort of management to conceal the fraud prevented them from discovery. The second is contributory negligence of management. The court found that the fraudulent act of management significantly contribute to the concealment of the fraud from the auditors. Therefore, the auditors could not be held liable for not detecting the fraud due to the active deception by management.
For auditor defense, in the case of Cenco Incorporated v. Seidman Seidman 1982, Cenco's management committed a massive fraud to inflate inventory values. When the fraud was discovered, Cenco's new management sued the audit firm for breach of contract, negligence, and fraud. The auditors defended themselves by arguing that they diligently tried to detect the fraud, but were misled by Cenco's own management. The 7th Circuit Court of Appeals ruled in favor of the auditors, concluding that the extensive involvement of Cenco's management in the fraud absolved the auditors of responsibility.
Assalamualaikum. So here I will discuss the principles or concept highlighted from the case. Firstly is prudent person concept. The prudent person concept mandates that auditors perform their duties with the care and diligence expected of a reasonably prudent person under similar circumstances. In this case, the audit firm defended itself by arguing that despite their efforts to detect fraud, Cenco's management had taken significant measures to conceal it. The court agreed, finding that the auditors were not negligent and had acted reasonably, aligning with the prudent person standard. Last but not least, legal terms affecting auditors' liability. Auditors' liability is shaped by legal principles such as negligence, breach of contract, and fraud. In this case, the auditors were accused of professional negligence, breach of contracts, and fraud. The 7th Circuit Court of Appeals ruled that the auditors were not liable as the fraudulent acts were orchestrated by Cenco's management. The court found that the auditors had met their professional duties, underscoring the challenges auditors face when management actively conceals fraud.